This is the brief on illegal assemblies and associations under the Revised Penal Code. So when does a crowd become a crime, or a club become a conspiracy? We're looking at that exact line today, drawn by Articles 146 and 147. First, let's tackle illegal assembly. This crime really comes in two forms. One is a meeting where armed people gather to commit crimes. And get this, not everyone needs to be armed. If the meeting's purpose is criminal, and even just a few people have weapons, everyone there is on the hook, even if they're unarmed. The other form is a meeting where the audience is incited to serious crimes, like rebellion or sedition. Here, the speaker is committing incitement, but the crowd itself? They're committing illegal assembly just for being part of it. Second, what about the group itself? That brings us to illegal associations. This punishes the very existence of the group, not a specific meeting. An association is illegal if it's organized to commit crimes, like the historical Laping Sakdalista, or if its purpose is just flat out against public morals. Founders, directors, even regular members are all liable. And finally, here's the key difference you gotta remember. Illegal assembly requires an actual physical meeting to happen, but for an illegal association, no meeting is necessary. The crime is just forming or joining the group itself. So Article 146 is about the act of gathering, while 147 is about the existence of the organization. It really makes you think about where organized advocacy crosses the line into criminal conspiracy.
Okay, so you ever wonder where the law draws the line between, say, a protest and an actual crime? Today, we're going to untangle two legal concepts that do exactly that: illegal assembly and illegal association. Now, they sound super similar, but trust me, the difference is crucial. Let's dive in.
It's a huge question, right? We get together all the time, for rallies, for club meetings, you name it. But at what exact point does a group of people cross a legal line and break the law? That's the core question we're tackling today.
So here's our game plan. We'll look at the specific laws, then we'll break down exactly what makes an assembly illegal, and then do the same for an illegal association. After that, we'll put them side by side to really nail down that core distinction. Everything we're talking about today, well, it all comes down to two key articles in the Revised Penal Code. You've got Article 146, which covers illegal assembly, and Article 147, which is all about illegal association. Think of these as the official rulebook.
All right, first up, illegal assembly. If you remember one thing about this, remember this phrase. It's a crime of the moment. It's all about a specific event, a particular gathering or meeting that goes wrong.
So, according to the law, a meeting becomes illegal in a couple of ways. Either the group got together with the intent to commit a crime from the get-go, or things kind of spiral, and someone starts inciting the crowd to do some really serious stuff, like treason or sedition. So the law really splits this into two different flavors. The first, and it's the more common one, is when you have a meeting of armed people who plan to commit any crime. The second kind is different. It doesn't even require weapons. It's all about riling up an audience and pushing them to commit these very specific, serious offenses against the state. Now, for that first type, the one with the armed meeting, the law has a very clear checklist. All three of these things have to be true. 1, there has to be an actual meeting happening. 2, at least some of the people there have to be armed. And 3, the whole point of the meeting has to be to commit a crime.
And here is a really, really important detail. Not everyone in the crowd needs to have a weapon. The law is clear. If even just some people at the meeting are armed, that can be enough to label the entire gathering as an illegal assembly.
This follows right from that last point, and it's a big deal. Just showing up, even if you're completely unarmed, could get you into legal trouble. The law basically sees your presence as a form of participation in what's happening.
So who actually gets in trouble? Well, the law sets up a kind of ladder of responsibility. The organizers and leaders are at the top. They face the most serious consequences. Then come the people with unlicensed firearms, followed by those with less serious weapons. And, at the bottom, but still on the ladder, are the unarmed people who are simply there.
Okay, let's switch gears and look at the other side of this coin. Illegal association. Now, if an assembly is the crime of the moment, you can think of an association as the crime of purpose. This isn't about one single meeting, it's about the entire reason a group exists in the first place.
See, here the focus isn't on an event, it's on the organization itself. A group becomes an illegal association if its entire reason for being, its core mission, is to commit crimes or to do things that go against public morals.
So, there are two main ways a group can fall into this category. The first one is pretty straightforward. You form a group specifically to commit crimes, like a gang or a syndicate. The second one is a bit more vague, being organized for a purpose that's contrary to public morals. And the liability here is structured differently too. The law makes a really clear distinction between the leadership, the founders, the directors, and just the regular members. The people who created and run the illegal group are held way more responsible than those who just signed up.
Okay, here we go. Time for the main event. Let's put these two ideas right next to each other so the differences become totally obvious. This is where it's all gonna click. This chart just makes it crystal clear, doesn't it? For an illegal assembly, you need an actual physical meeting. It's about being there at an illegal event. But for an illegal association, you don't need a meeting at all for it to be a crime. The crime is the act of forming the group or just being a member, even if you never all get in the same room. So let's just boil all this down to the one key takeaway. The single most important difference you need to remember.
Here's the easiest way to think about it. An illegal assembly is like a single illegal event. It's temporary. An illegal association, on the other hand, is like the club that exists to throw those illegal events. It's a permanent, ongoing thing with an illegal purpose at its core. It's basically the event versus the club.
The bottom line is this. If you want to tell them apart, just ask yourself one simple question. What is the law actually punishing? Is it the one-time, temporary act of meeting? That's an assembly. Or is it the ongoing act of organizing and belonging to a group? That's an association.
And this all leaves us with a much bigger question. These laws draw an incredibly fine line. They're trying to keep people safe and maintain public order, but they're operating right up against our fundamental right to gather and associate freely. Understanding this stuff isn't just a legal trivia game. It's about seeing how our society constantly tries to strike that delicate balance between security and freedom.
Welcome back to the Deep Dive. We're really glad you're here with us today.
Absolutely.
I was thinking on the way into the studio about how much of our lives are, they're defined by the people we surround ourselves with.
Sure.
We have our work friends, our weekend crew, maybe a book club or a sports team. It feels incredibly natural, right?
Yeah.
The right to just gather, to be together.
It is fundamental. I mean, you hear about the social animal concept.
Right.
We congregate, we do it to celebrate, to commiserate, to complain, and to plan. It really is the oxygen of a free society.
It's the air we breathe. Exactly.
Yeah.
But today, we're going to look at the moment when the air gets sucked out of the room. We're looking at the edge of the map, We're exploring the moment where that simple, fundamental act of getting together stops being a right and crosses an invisible line into becoming a crime.
And it is a thinner line than most people probably realize. We're not talking about a full-blown riot where, windows are being smashed and cars are on fire.
Yeah.
We are talking about the gathering itself being the criminal act.
We've got a stack of sources today that are going to take us right into the weeds of Chapter 3 of the Revised Penal Code.
A really fascinating chapter.
It really is. And specifically, we're going to be dissecting Article 146 and Article 147. These are the laws that define illegal assemblies and illegal associations.
And that distinction is crucial. It's something we are going to hammer home over the next hour. The difference between an assembly, which is an event, a moment in time.
Right, a specific gathering.
Exactly. And an association, which is a structure. It's a group that exists whether they're all in the same room or not.
I have to tell you, reading through these source documents, there were moments where I literally stopped and just reread the sentence. Because we usually assume that criminal liability requires action.
It requires an act, yeah.
I have to do something, I have to pull a trigger or steal a wallet or throw a punch. But the source material here introduces concepts like persons merely present.
That is the phrase. That's the one that keeps legal scholars up at night. Merely present.
It sounds dystopian. It implies you can be liable, you can face actual jail time just for standing in the back of the room holding a cup of coffee if the meeting itself is deemed illegal.
It creates a scenario of guilt by proximity.
Guilt by proximity. That's a great way to put it.
The law essentially places a burden on you, on every citizen, to know the company you keep and crucially to know the purpose of the gathering you're attending.
And we are definitely going to talk about the bolos.
Oh, yes, we have to talk about the bolos.
It's such a specific detail in the text.
It's so culturally grounded, but it tells us so much about the intent and the history of this law.
Okay, so here is our mission for this deep dive. We are going to unpack the specific requisites, the ingredients, really, that turn a lawful meeting into an illegal assembly.
We'll break it down piece by piece.
We are going to look at the hierarchy of liability. Who is in more trouble, the guy with the megaphone or the guy just standing in the crowd, and why? Then we're going to pivot to illegal associations, where you don't even need to have a meeting to break the law.
It's a fascinating study in how the state draws boundaries around organized behavior. It's really all about where the line is drawn.
Let's jump right in then. Article 146, illegal assemblies. The source material breaks this down into two very distinct forms. Two ways a meeting can be illegal. Let's start with the first form.
Right, the first form. If we look at the source definition, it's actually quite specific. It describes a meeting attended by armed persons for the purpose of committing crimes punishable under the Revised Penal Code or the RPC.
Okay, let's unpack that because there are three distinct ingredients there, and I want to make sure we understand how they all have to mix together.
Think of it like a recipe for a prison sentence. You need all three things. You need the gathering, you need the weapons, and you need the purpose.
If you take one of those away.
If you take one away, you might still have a problem. You might be committing some other crime, but you don't have this specific crime of illegal assembly, first form.
Got it. Okay, let's look at that first ingredient, the gathering. The source says, meeting, gathering, or group of persons. That seems, well, deliberately broad.
It has to be. You can't let someone get off on a technicality, arguing, oh, Your Honor, it wasn't a meeting, it was a conclave.
Right. Semantics?
The law tries to close those loopholes, so it doesn't matter what you call it. If people are congregated, it's a gathering.
And does it matter where they are?
Not at all. And this is an important point to visualize. The source notes that this law applies whether the group is in a fixed place or moving.
Okay, so a fixed place is easy to imagine. We're in a basement, we're in a warehouse somewhere, the secret back room of a bar.
Correct. Or even a public park. If you're standing still, you are a gathering. That's straightforward.
But the moving part is really interesting. So this could apply to a march, a protest.
Absolutely. A procession. If you have a group of people walking down the highway together or parading through the town square legally, that is a meeting or gathering for the purposes of this article.
So you can't use the excuse, we weren't meeting, officer. We were just taking a very coordinated walk together.
Exactly. The law doesn't care about your velocity. It cares about your cohesion as a group. If you're together acting as a unit, you satisfy the requisite of a gathering.
Does the law say how many people make a group? I mean, is it 3 people, 10, 100? Is there a number?
That is a great question. The Revised Penal Code in this section, it doesn't actually set a hard number. It's not like in some other statutes where it might say 3 or more persons.
Oh, interesting.
It's more about the nature of the gathering than a specific head count. So it becomes a qualitative assessment for the courts, not just quantitative.
So 2 guys in a car plotting something probably wouldn't be an assembly in this sense. That's something else.
Probably not, no. That would more likely fall under conspiracy laws. Assembly implies a certain public character, a mass, even if it's a small one, that poses a threat to public order just by its existence as a group.
Okay, so we have the group, fixed or moving. Now comes the second ingredient, and I think this is the one that people immediately visualize when they hear illegal assembly. The armed element.
This is the critical differentiator for the first form. The meeting must be attended by armed persons.
Mm-hmm. Without
that, you don't have this crime.
But here is where it gets tricky, and I want to make sure I understand the source correctly. Does everyone at the meeting need to be armed? If there are...
That absolutely counts. That meets the requisite. The meeting is attended by armed persons. The presence of those 5 or 6 armed individuals taints the entire gathering under the law.
That feels like a really rigorous standard.
It is. The logic behind it is that the presence of weapons within the group fundamentally changes the character of the entire gathering.
How so?
It escalates the potential for violence instantly. It changes the psychology of the room. It's no longer just a debate society or a disgruntled group airing grievances. It's a potential fighting force. The state sees that potential and acts.
Which brings us to the third ingredient, the purpose. It's not enough to just be a group with some guys carrying guns. I mean, maybe you're a hunting club meeting at a lodge or a security detail on a break.
Exactly. Intent matters. The meeting has to be for the purpose of committing crimes punishable under the RPC.
The Revised Penal Code.
Correct. So we're talking about the big ones: murder, homicide, kidnapping, arson, robbery, serious felonies.
So if you are gathering with guns to plan a bank robbery,
that is the textbook definition of an illegal assembly first form.
if you are gathering with guns to plan the kidnapping of a local official,
that is an illegal assembly.
and the key thing here, and tell me if I'm wrong on this, is that they haven't actually robbed the bank yet.
Not yet.
They haven't kidnapped anyone yet. They're just in the room talking about it, planning it.
Precisely. This is a preemptive law. It's designed to nip the crime in the bud. The state is saying, we are not going to wait for you to storm the bank with guns blazing. The fact that you are gathered here with weapons plotting this crime is a danger to public safety in and of itself.
So it's criminalizing the preparation.
It does. It attacks the conspiracy before it can manifest into the substantive crime. The assembly itself is seen as the first overt act.
Now, this leads us to the part that I found, frankly, the most unsettling. We established that not everyone needs to be armed. But the source goes on to say something very specific about the liability of those unarmed people, the 94 people in my earlier example.
Yes. This is what you called the guilt by proximity issue. Some call it the innocent bystander problem, or rather, the lack of innocence in the eyes of the law. The source states, however, even unarmed persons merely present at the meeting are also liable.
That just stops me in my tracks every time I read it. So let's go back to that hypothetical room. I'm one of the people without a gun.
Mm-hmm.
I'm just sitting there. Maybe I'm just listening. Maybe I'm just curious about what the guys with the guns have to say. I haven't done anything. I haven't held a weapon. I am liable for illegal assembly.
Yes. Under the first form of Article 146, you are liable. You can be arrested and charged right alongside the organizers and the armed men.
Why? I mean, that feels, well, to a layperson, that feels unfair.
Yeah.
If I'm not the one providing the direct physical threat, why am I treated as a criminal just for being there?
It comes down to the concept of collective force. Think about it from the perspective of the state or the police who might have to deal with this gathering. A group of 5 armed men standing alone in a field is dangerous, yes. But a group of 5 armed men surrounded by a supportive or even just passive crowd of 95 people, that is a fortress.
So the unarmed crowd acts as what? A human shield.
They act as a shield, absolutely. They act as camouflage. It's much harder for law enforcement to spot the actual shooters in a crowd, and they act as a force multiplier. They provide the mass, they provide the intimidation factor.
I see. That makes sense. A mob is scarier than 5 guys.
Also, think about the psychology of the armed men themselves. If they were standing alone, they might feel vulnerable, exposed, they might hesitate. But if they have nearly 100 people cheering them on, or even just silently witnessing and standing with them, they feel emboldened.
Right. They feel powerful.
Exactly. So your presence, even if you're silent, even if you're in the back, essentially validates and strengthens the armed group. You are lending them your tacit support.
So by being there, I am contributing to the mass of the assembly. And given the purpose that this meeting is to commit a crime, the law just presumes I'm part of that danger.
The presumption is that you know what you're there for. You see the armed men, you hear the criminal plot being discussed, and you choose to stay. That choice is what the law criminalizes.
So ignorance could be a defense. I mean, if I genuinely didn't know they were armed or what they were planning.
The source doesn't explicitly delve into all the possible defenses, but in general, criminal law, intent is key, mens rea.
The guilty mind.
Exactly. However, the statute for illegal assembly focuses heavily on the objective facts. Was there a meeting? Yes. Were there armed people? Yes. Was the purpose criminal? Yes. If you are there, the burden of explaining why you were just innocently hanging out with an armed criminal mob falls very, very heavily on you.
It's a sobering thought. It really means you have to be acutely aware of your surroundings. If you walk into a meeting and see guns on the table, the law expects you to turn around and leave.
Immediately. Do not pass go. Do not finish your coffee. Leave. Because staying makes you complicit in the eyes of the law.
Absolutely fascinating. Okay, now, that covers the first form pretty thoroughly. But Article 146 has a second form, and this one is quite different. It shifts the focus away from planning a crime and more towards inciting a crowd.
Right. Let's look at the second form. The source defines this as a meeting where the audience is incited to the commission of some very specific crimes.
And notice the specificity here. In the first form, The purpose could be any crime under the Revised Penal Code. Murder, arson, robbery, you name it. But in the second form, the list is much shorter and much more specific.
It is. The source lists them clearly. Treason, rebellion or insurrection, sedition, or assault upon a person in authority.
These are all crimes against the state.
Yes.
These are crimes against public order. This isn't about robbing a bank anymore for personal gain. This is about overthrowing the government or attacking its agents.
Exactly. This is the political dimension of the law. This part of the article is designed to protect the stability of the state itself.
Now, let's play the comparison game again, because this is where it gets clear. In the first form, the armed plot, we absolutely needed armed people. What about in this second form, the incitement form?
This is a major, major distinction. The source says, the audience, whether armed or not.
So weapons are optional here. They don't matter for the charge.
Correct. In the second form, the danger doesn't come from the guns and the belts of the attendees. You could have a crowd of thousands of people wearing t-shirts and shorts, holding nothing but placards or water bottles.
And it can still be an illegal assembly.
Yes, because in this form, the weapon is the incitement itself. The danger comes from the words being spoken from the stage and the potential reaction of that crowd.
A completely unarmed crowd can still be dangerous.
An unarmed crowd can be incredibly dangerous. They can overwhelm authorities with sheer numbers. They can cause chaos, block streets, storm buildings. You don't need a gun to be part of a rebellion.
So the idea is that the speech acts as the trigger. The words are the weapon.
That's a perfect way to put it. The words are the weapon that can turn a peaceful crowd into a seditious mob.
This brings us to what I'm calling the double crime scenario in my notes. The source outlines a really interesting legal interaction here between the speaker, the one doing the inciting, and the audience. It seems like one event triggers two different charges depending on who you are.
Yes, this is a classic law school examination point. You have one event, one rally, but the law slices the liability differently based on your role.
So let's break it down. I'm standing on the stage. I'm the charismatic leader with the microphone. I'm shouting at the crowd, telling them to rise up, to storm the palace, to commit sedition. What crime am I committing?
You, the speaker, are committing the crime of inciting to rebellion or sedition. That is a specific crime under a different article of the code.
Yeah.
You are the instigator. You're the one lighting the fuse.
Okay. And what about you? You're in the audience. You are just listening. You haven't thrown a rock yet. You haven't stormed the palace. You're just standing there, maybe nodding along, maybe getting swept up in the moment. What crime are you committing?
I and the organizers of the meeting and everyone else present in that audience are committing the crime of illegal assembly.
That is fascinating. So the speaker gets hit with the inciting charge, and the listeners get hit with the illegal assembly charge, all from the same speech.
It creates a comprehensive net of liability. The law punishes the spark, that's the speaker, and it punishes the fuel, that's the assembly.
You can't have a fire without both.
Essentially. The law recognizes that a charismatic speaker is harmless without an audience, and an audience is just a crowd until a speaker gives them a seditious purpose. So it goes after both sides of the equation.
It really emphasizes that being an audience member isn't a passive role in the eyes of the law. If you are lending your ears to sedition, you are actively participating in an illegal assembly.
Precisely. And this is where the freedom of assembly hits that hard wall. You know, you have the right to assemble, to petition the government for redress of grievances. That's constitutional. It's fundamental.
Of course.
But the moment that assembly becomes a venue for inciting treason or sedition, meaning actively urging people to break the law and attack the state, the constitutional protection evaporates and the penal code takes over.
So we've covered the two forms. First form, armed meeting for general crimes. Second form, incitement to specific political crimes, armed or not. Now, we have to talk about consequences, because the source material has a whole section on penalties, and it creates a very clear hierarchy of responsibility.
It does. Not everyone is punished equally, which is logical. The law distinguishes between the organizers or leaders and the persons merely present.
And I'm going to assume the leaders get the heavier hammer.
Always. The organizers or leaders face the stiffest penalties. It's a principle you see throughout criminal law. The architects of the danger are held most accountable. They brought the people together, they set the stage, they created the situation.
But the persons merely present aren't off the hook, as we've discussed at length. But their penalty depends on something very specific. The source breaks this down into categories based on what they were holding in their hands.
This is where the weapon escalation comes in. The law looks at the individual liability of the person in the crowd and asks, okay, you were there, But how dangerous were you specifically? How much did you, as an individual, contribute to the immediate physical threat?
Let's walk through the tiers. Category 1 for a person merely present, not armed.
Right. So you're liable, but it's the lowest tier of punishment for someone present. You were there, you added to the numbers, you provided that mass we talked about, but you weren't carrying a weapon. The law punishes you, but it recognizes you were less of a direct threat than the guy next to you with a knife.
Okay, that makes sense. Now, category 2. This is where the source gets really specific and honestly really interesting from a cultural standpoint. It lists bolos or knives or licensed firearms.
Right. If you are carrying what the law considers a deadly weapon, your penalty goes up significantly. You've crossed a line.
I have to pause on bolos. For our listeners who might be tuning in from other parts of the world, or even for locals who just see it as a tool, a bolo is essentially a machete.
A large single-edged knife, yes.
It's a farming tool. In many rural areas, everyone has a bolo. You use it to clear grass, to chop coconuts, to open boxes. It's like a utility knife.
It is a ubiquitous tool, absolutely. It's a symbol of agricultural life, of labor. But, and this is the key, in the context of a gathering, especially one with a criminal purpose or a seditious intent, that tool is recontextualized.
How so? It's the same object.
The context is everything. The law recognizes that a bolo can be just as lethal as a combat knife or a gun in close quarters. If you bring a bolo to a meeting where the speaker is inciting rebellion, the presumption is that you aren't there to harvest rice.
The presumption shifts. It's no longer a tool, it's a weapon.
It becomes a weapon of aggression. Your intent is inferred from the circumstances.
It really contextualizes the law, doesn't it?
Yeah.
It shows that this code was written with a very specific social landscape in mind, but it's fascinating that it is grouped right there with licensed firearms.
Yes. So if I show up with my legally registered pistol, which I went through a whole process to acquire, and you show up with your farm bolo, in that moment, at that illegal assembly, we are in the same boat regarding penalties. We are both considered armed with deadly weapons.
But here's the kicker. Category 3, the highest penalty for a person merely present, the top of the danger chart.
Unlicensed firearms.
Now, help me understand the logic here. Why is an unlicensed firearm treated so much more severely than a licensed one? I mean, from a physics standpoint, a bullet is a bullet. If I get shot, it doesn't really matter to me if the gun was registered at Camp Crame. It still hurts.
That's a valid point regarding the physical damage, but the law isn't just looking at the physical damage. It's looking at the intent and the level of criminality signaled by the weapon.
Okay, break that down.
Think about it. If you have a licensed firearm, you have gone through the legal process.
Yeah.
You have submitted your name, your address, your fingerprints to the government. You are, at least on paper, a law-abiding gun owner. You might be able to argue, however weakly, that you brought it for self-defense.
Okay, I can see that. You're part of the system.
But if you bring an unlicensed firearm to a meeting, that is a loose firearm. By the simple act of possessing it, you are already breaking the law, a serious law.
It's a crime on top of a crime.
Exactly. It suggests a much higher degree of criminal intent. It suggests you are operating completely outside the legal system. You are actively hiding from the state. Therefore, the law views you as a fundamentally greater threat. You are a rogue element.
So if you're at an illegal assembly, the person with the registered pistol gets a lighter sentence than the person with the ghost gun or the smuggled weapon.
Precisely. It's a hierarchy of bad intentions reflected in the object you chose to carry. The unlicensed gun is seen as proof that you are there for no good reason and you have no respect for the legal framework whatsoever.
This is a lot to take in regarding events. We've really dissected the idea of the assembly. But the deep dive doesn't stop there. We have to pivot to the other half of this chapter. We need to talk about Article 147, illegal associations.
This is the critical transition from the event to the structure, from the momentary mob to the organized syndicate.
The source makes a really big deal about distinguishing assembly from association. What is the fundamental difference? If I'm explaining this to a friend over coffee, what's the one thing I absolutely need to get right?
The most important difference, the one everything else flows from, is the need for an actual meeting.
Go on.
For a legal assembly, Article 146, which we just spent all this time on, you need an actual meeting. People have to show up. It has to happen in time and space.
Okay. And for a legal association?
No meeting is necessary. None whatsoever.
That is a huge distinction. That changes everything.
It does. Illegal association punishes the act of forming or being a part of the organization itself. The crime is the very existence of the group.
So let me get this straight. We could be part of an illegal association, never actually meet in person, just communicate via letters or, in a modern context, encrypted apps, and we are still liable.
Yes. If the association falls under the definitions in Article 147, the mere act of organizing it or joining it is the crime. You don't need to wait for the rally. You don't need to wait for the secret meeting. The membership card in your pocket is the evidence of the crime. The group chat on your phone is the evidence.
Wow. Okay, let's look at the forms of illegal association then. The source lists 2 types. What's the first one?
The first type is fairly straightforward based on what we've already discussed with assemblies. It covers associations that are totally or partially organized for the purpose of committing crimes punishable under the Revised Penal Code.
So this is basically organized crime, a formal structure for law breaking.
Essentially, a kidnapping ring. A group of professional bank robbers who have a formal structure, a leader, members. If the entire purpose of your club is to break the penal code, it's an illegal association.
The source actually cites a specific case here, People versus Ramos, and it mentions a group called the Lapiang Sakdalista.
Yes, this is a historical reference that adds a lot of color and context to the law. The Lapiang Sakdalista was a political movement in the Philippines back in the 1930s.
A political movement, not just a gang.
Exactly. They were a radical party advocating for immediate independence from the United States, land reform, tax cuts, but they were involved in what's known as the Sakdal Uprising.
So they took up arms.
They did. And the court, in that case, declared them an illegal association because their purpose, or at least the means they eventually adopted, involved an uprising. They were seen as organizing for the purpose of sedition and rebellion.
It's a powerful reminder that these laws have been used in very real, very heavy political moments in history. It's not just theoretical law school stuff. This is about how the state handles organized rebellion.
Absolutely. But now, look at the second form of illegal association. This is the one that usually sparks the most debate when we discuss this topic. It's much more amorphous.
I was looking at this. It says, associations totally or partially organized for some purpose contrary to public morals.
Public morals.
That is incredibly vague, isn't it? I mean, crimes under the RPC, murder, theft, arson, those are defined. I can open the book and read the definition, the elements. But public morals, who defines that?
That is the million-dollar question, and that is where the law becomes subjective and, some would argue, potentially dangerous. Public morals acts as a catch-all phrase.
And it changes over time.
It changes dramatically over time. What was considered contrary to public morals in 1930, when the code was written, might be completely acceptable or even celebrated today.
Can you give us an example of how this might work? What kind of group would fall under this?
Well, historically, this could have been applied to groups promoting activities that were seen as vices, like certain forms of gambling or perhaps prostitution rings.
Things that weren't necessarily a violent crime like murder, but were seen as corrupting.
Exactly. Groups organized around an activity that society at that time deems indecent or harmful to the social fabric. It could even, in some interpretations, extend to cults or other organizations deemed socially destructive.
So it gives the state a lot of leeway, a lot of discretionary power.
It does. It allows the state to shut down organizations that it deems harmful to the social fabric, even if they aren't planning to overthrow the government or rob a bank. It effectively says that you cannot organize a group if your fundamental goal is to degrade the moral standards of the community.
But that's a moving target, that definition of morality.
It is, and that's what makes it so legally tricky. A group advocating for a radical lifestyle change might be seen as immoral by one administration and progressive by the next, but under Article 147, if a court deems the purpose contrary to public morals, the association itself is illegal, period.
So we have the crime club and the immoral club. Both are illegal associations. Now let's talk liability. Who goes to jail for these?
Similar to what we saw with Assembly, we have a tiered system of responsibility.
The source lists founders, directors, and the president of the association.
The leadership, the brains of the operation, they face the highest penalties because they created the structure. They built the engine of the crime or the immorality. They are the most culpable.
And then, after the leadership.
Mere members of the association.
Mere members. There's that word mere again. Just like mere presence at the assembly.
Yes, if you signed up, if you pay dues, if your name is on the roster, you are liable.
So if I joined the immoral club just to see what it was about, but I never went to a meeting, I never actually did anything immoral myself?
You are liable under Article 147. Your membership is your crime. The act of joining is the act that breaks the law.
So let's synthesize this. We have Article 146 for the Assembly, and Article 147 for the Association. How do we keep them straight in our heads?
Here's the easiest way to think about it. In Article 146, the illegal assembly, you are liable for being present at a specific dangerous event.
It's about an action happening in real time.
Yes. It's about where you are and what is happening right now. It is kinetic. It's in motion.
And in Article 147, the illegal association.
You are liable for belonging to a dangerous group. It's about who you are with and what you represent as a member, regardless of whether a meeting is happening right now or ever happens. It is structural. It's about your status.
It really covers all the bases. You can't meet illegally, that's assembly. And if your purpose is illegal, you can't even exist as a group in the first place, that's association.
That is the design of the Revised Penal Code. It intends to leave no gaps for organized criminal or socially harmful activity to flourish, whether it's a momentary mob or a long-term syndicate.
This has been quite the journey through Chapter 3. It's heavier, more complex than I expected.
It's a dense chapter, but it's a profoundly important one. It really defines the boundaries of our freedom to gather and associate with one another.
So let's wrap this up with some key takeaways for you, our listener. If you're taking notes, here is the cheat sheet from today's deep dive.
First, remember the two forms of illegal assembly. You have the armed plot, where people meet with weapons to plan or commit a crime.
And the incitement crowd.
Yes, where a crowd is whipped up into sedition or rebellion, and it doesn't matter if they're armed or not.
Second, and this is maybe the biggest one, remember the concept of guilt by presence. In an illegal assembly, you don't need to be the one holding the gun or the microphone. If you're there and you know what's happening, you're on the hook. The crowd itself is part of the crime.
Third, remember that fundamental difference between the temporary and the permanent. Assembly is the event. Association is the organization. You can be punished for attending the event under 146 and for being a member of the organization under 147.
And finally, that public morals clause in Article 147. It's a sleeper provision, it's broad, it's vague, and it reminds us that the law is designed to enforce not just public safety, but also a certain vision of social order.
It's the area of the law that requires the most vigilance, I think, from a civil liberties perspective.
Before we sign off, I want to leave you with a thought to chew on. We talked at length about public morals. Since the text doesn't define it explicitly, it leaves it wide open to interpretation. So think about the organizations you know today. Are there groups out there that are deeply unpopular? Groups that challenge the status quo in ways that make people uncomfortable?
It raises an important and timeless question. How do we as a society define what is contrary to morals versus what is simply unpopular or unconventional?
Exactly. At what point does challenging the norm cross the line into being contrary to public morals in a legal sense? It's a fine line. And also, just a practical tip from today's discussion. Be aware of the purpose of any gathering you attend.
Know who you're with.
Know who you're with, because ignorance of the organizer's true intent or ignorance of the fact that the guy next to you has a bolo tucked under his jacket, it might not be enough to save you.
Stay informed and stay safe.
Thanks for diving deep with us. We'll see you on the next one.
Welcome to The Debate. Today we are opening the books on what might be one of the most uncomfortable tensions in criminal law, the conflict between your individual intent and your collective liability. We're looking specifically at Articles 146 and 147 of the Revised Penal Code concerning illegal assemblies and illegal associations.
It's a fascinating and frankly a slightly terrifying area of the law. It really challenges the standard assumption we all, walk around with, this idea that you're only responsible for what you do. These articles suggest that who you stand with or who you sign up with can be just as incriminating as pulling a trigger yourself.
Precisely. The core question we're tackling today is this. At what point does a gathering or a membership become a crime? Does criminal liability attach to the individual based on their specific actions? Did they hold the gun? Did they scream the threat? Or does the law punish the collective act of gathering regardless of whether a specific person is armed or unarmed?
And that is, I think, exactly where we're going to diverge today. You tend to view this through the lens of a strict structural liability, that the group is the weapon.
I do. I believe the text of Articles 146 and 147 creates a framework where mere presence or membership is sufficient for punishment because the danger lies in the collective mass itself. The law is really designed to dismantle the structure of violence before it can act.
I see the logic, but I come at it from a slightly different angle. I believe the text reveals some critical distinctions, specifically regarding the armed status of attendees and the, incredibly nebulous definition of public morals. These distinctions suggest the law requires or at least implies a much higher threshold for individual culpability. There are layers here that I think are designed to protect the innocent bystander, and if we ignore them, we risk criminalizing legitimate dissent.
Let's test that theory. I want to start by laying out my position on Article 146, specifically regarding illegal assemblies. The law effectively identifies two forms of illegal assembly, but the first form is the most illustrative of my point regarding this collective danger. This is defined as a meeting attended by armed persons for the purpose of committing crimes punishable under the Revised Penal Code.
On the surface, that seems reasonable. I mean, if you bring a gun to a meeting to plan a bank robbery or a rebellion, you expect the law to step in.
But look closer at the requisites. The text explicitly states that not all persons attending the meeting need be armed. That is the crucial pivot point. The law recognizes that in a mob or a criminal gathering, the weapons might be distributed among a few, the muscle, if you will, but the force is provided by the many. The text then goes on to clarify the liability. However, even unarmed persons merely present at the meeting are also liable.
Merely present. That is the phrase that just keeps tripping me up.
It should wake you up. The law views the meeting itself as the danger. If you are there and the purpose is to commit a crime under the RPC and someone is armed, you are liable. The structure of the assembly is what communicates the threat. The law does not ask if you personally held the knife. It asks if you were part of the body that wielded it.
That is a compelling argument for collective security. I'll give you that. It's the strength in numbers argument turned against the crowd. But I'm sorry, I just don't buy that it's that cut and dry. While the law punishes presence, the text offers specific requisites and classifications that, I think, imply we must look closer at the nature of the gathering. We can't just ignore the granularity in the text.
What granularity are you referring to?
Well, look at the classification of weapons at Article 146. It doesn't just say weapons. It lists bolos or knives or licensed firearms, and it distinguishes them from unlicensed firearms. And then if you look at Article 147, which deals with illegal associations, it distinguishes between associations organized for crimes and those organized for purposes contrary to public morals.
But those are just categories for sentencing. They don't change the fundamental criminality of the act itself.
I think they're more than just sentencing guidelines. They suggest that the quality of the threat matters. The text distinguishes between the organizers or leaders and persons merely present. Now, if the liability were purely structural and equal, these distinctions wouldn't be so sharp. I think the law is trying to parse out the level of danger. A gathering with licensed firearms is treated differently in the text than one with unlicensed firearms. This implies that the law is looking for specific indicators of intent and capacity for violence, not just a blanket punishment for standing in a crowd.
I want to push back on that because I think you're reading mercy into a text that is actually quite rigid. Let's move into the core of the debate, specifically regarding that first form of illegal assembly in Article 146. You mentioned the weapons distinction, but I want to focus on the armed requirement and the liability of the unarmed.
Go on.
The requisite is a meeting where some are armed. The argument I'm making is that the presence of armed individuals fundamentally changes the nature of the gathering for everyone in that room or on that street corner. The text specifies liability for persons merely present who are, and it quotes, not armed. It doesn't say unarmed persons who knew about the weapons or unarmed persons who cheered on the gunman. It just says not armed.
But think about the practical implication of that. We're talking about real life here.
The implication is clear. If you join a group where bolos, knives, or firearms are present for the purpose of committing a crime, you have crossed the line. The text explicitly states the requirement that persons be armed applies only to the first form of illegal assembly. Yet the liability extends to the unarmed attendees. The law is saying you cannot hide behind empty hands if you are lending your body to an armed mob.
That is a frighteningly broad net, though. I challenge this because it creates a difficult, almost impossible situation for the mere present individual.
I mean, how does one distinguish a legitimate crowd from an illegal one if they aren't the ones holding the bolos or knives? Imagine a political rally. It starts peaceful, you're there to chant, two guys 10 feet away have concealed knives. Suddenly you're a criminal?
The purpose of the meeting guides that distinction. It's not just the presence of weapons, it's the purpose of committing crimes under the RPC. If the rally is for a lawful purpose, the rogue actor with a knife is an anomaly. But if the meeting is for the purpose of committing a crime, then the presence of the weapon infects the whole gathering.
Perhaps. But I'm looking at the list again. Bolos or knives or licensed firearms versus unlicensed firearms. Why does the text break these down if the only thing that matters is the collective gathering? The specific listing of unlicensed firearms suggests the law is highly concerned with the legal status of the weapon itself. It implies that the individual's capacity for violence and the legality of their tools is central to the severity of the crime. If I'm unarmed and I'm standing next to someone with a licensed firearm versus someone with an unlicensed firearm, does my liability shift? The text differentiates these for a reason.
I would argue those distinctions exist for sentencing phases to determine how long you sit in jail, but the criminality of the assembly remains constant. But let's look at a scenario where weapons aren't even required. This, I think, undermines your idea that the quality of the weapon is a defining factor. I want to talk about the second form of a legal assembly under Article 146.
This is the form regarding incitement?
Yes, this is defined as a meeting where the audience is incited to treason, rebellion, insurrection, sedition, or assault upon a person in authority. Here is the key distinction that undermines your focus on weapons. In this form, the text says the audience can be armed or not. The weapon requirement vanishes entirely.
Right, whether armed or not. That's a massive shift.
Exactly. This proves the law focuses on the purpose of the gathering, not the hardware. The text notes that the crimes committed are illegal assembly as regards the organizers or leaders and persons merely present. The listener, the audience member, is liable for illegal assembly simply for being there and listening to the incitement.
And that is where I find the audience liability deeply troubling. We're effectively talking about the criminalization of listening.
It's not just listening, it's participating in a seditious gathering. The text clarifies that while the speaker is liable for inciting to rebellion or sedition, the audience is liable for illegal assembly. The roles are distinct, but the liability is shared.
But look at the phrasing. The audience is incited. That's passive voice. The audience is the object of the action, not the subject. They're being acted upon. Yet the text assigns criminal liability to those merely present.
Because their presence provides the platform, you cannot have incitement without an audience. Without the crowd, the speaker is just a crazy person shouting at the wind. The crowd validates the message. The crowd is the amplifier.
That's a fair point regarding the mechanics of a speech, but it blurs the line between curiosity and conspiracy. If I stop to listen to a speaker who suddenly starts calling for treason, at what millisecond do I become a criminal? The text is silent on the duration or the reaction of the audience. It just says if the audience is incited, they're liable. It seems to strip the individual of agency. In Form 1, you arguably choose to stand with armed men. In Form 2, you are liable for what someone else says to you.
I see your hesitation, but I would frame it differently. The law assumes that one does not accidentally find themselves in a meeting where rebellion or sedition is being preached. These aren't pop-up events, they are calculated gatherings. The law is telling you that you have a duty to disengage. If the speech turns to sedition, your presence is no longer neutral.
A duty to disengage is one thing, but criminal liability for mere presence is another. It implies that the state can arrest an entire room of people because one person on stage broke the law. That feels less like justice and more like a dragnet.
It feels like a dragnet because the crime is the gathering itself. But let's shift gears to where the meeting itself becomes irrelevant. This is where my argument about structural liability becomes, I think, undeniable. Let's talk about Article 147 and illegal associations.
This is the distinction as to need for actual meeting?
Correct. The text clarifies that a legal association does not require an actual meeting. This supports my structural argument perfectly. The crime isn't the event. The crime is the organization itself. The text cites People versus Ramos, declaring the Lapillon Sactalista as an illegal association. They didn't need to be caught in a room together. The existence of the group was the crime.
I agree that Article 147 removes the meeting requirement, but it introduces a new ambiguity that I think supports my view that we need to be very careful with how we apply this. It feels like thought policing if we aren't careful.
How so?
Look at the forms of illegal association listed in the text. Form A is straightforward. Totally or partially organized for purposes of committing crimes punishable under the Revised Penal Code. That parallels Article 146. If you organize a club to commit murder, that's illegal. Fine. But look at Form B.
Totally or partially organized for some purpose contrary to public morals.
Exactly. Contrary to public morals. That is incredibly subjective compared to the hyper-specific list in Article 146, which lists treason, rebellion, insurrection, and sedition. In Article 146, we know exactly what crimes we're trying to prevent. In Article 147 Form B, a group can be declared illegal if its purpose is just contrary to public morals. Who defines that?
Public morals are a standard concept in legal theory, though. It refers to the fundamental decency and order of society. It's not just about etiquette. It's about organizations that erode the fabric of the community.
But in criminal law, we usually demand precision. If I join a group that advocates for something radical, say a specific type of gambling that isn't technically illegal yet, or a lifestyle choice that the majority frowns upon, am I in an illegal association? The law creates liability even if the group is only partially organized for these purposes. So you have a vague definition of the offense, public morals, and a low threshold for the structure, partially organized. That is a recipe for overreach.
I'm not convinced that partially organized implies a low threshold. I think it implies that the law is proactive. It doesn't wait for the organization to be fully mature before striking it down. If you're a founder, director, or president of such an association, or even a mere member, you are liable. The law says we don't have to wait for the moral decay to set in.
But again, look at the person's liable section. It feels like you're glossing over the hierarchy the law establishes.
I am looking at it. It lists them clearly.
It lists them separately. Founders, directors, and president in subsection A, and mere members of association in subsection B. Just as in Article 146, where it lists organizers or leaders separately from persons merely present.
Because they are different roles.
Yes, but the fact that the text bothers to separate them, rather than just saying all members and leaders, suggests a hierarchy of responsibility. The text is acknowledging that the foot soldier is not the general. Punishing mere members of association under Art 147 carries a different weight than punishing organizers under Art 146. The law recognizes that the mere member might not fully understand the scope of the organization, whereas the founder absolutely does.
But they are both soldiers in the eyes of the statute. That is my point. The hierarchy exists, likely for penalties, but the liability is absolute. Whether you are the president of the Lapillon Sactalista or a mere member who just signed a card, you are part of an illegal association. The law is comprehensive. It captures everyone. Leaders, members, armed attendees, unarmed attendees. It seals the cracks so that no one can claim ignorance.
It seals the cracks, but it might be sealing people inside who don't belong there. The distinction in Article 146 regarding the weapon types, bolos, knives, unlicensed firearms, and the distinction in Article 147 regarding public morals all point to a legal system that is trying to grade the severity of the threat. If the law was purely about structure, it wouldn't care if the gun was licensed or not. It wouldn't care if the association was against public morals or RPC crimes. It would just ban the group. The nuance is in the text for a reason.
And I would argue the nuance is there to ensure that no version of the threat escapes. By specifying licensed versus unlicensed, it ensures that even those with legal weapons are caught if the purpose of the meeting is illegal. By specifying public morals, it ensures that groups which are destructive but don't strictly violate the RPC are still dismantled. It's not about mercy, it's about total coverage.
That is a grim but effective interpretation.
It is the interpretation that keeps the peace. If you allow the mere members to walk away, you essentially allow the army to reform the next day under a new leader. To stop the association, you have to penalize the membership. If you make membership itself toxic, the organization dies.
Or you suppress legitimate assembly by making people too afraid to join anything. We're looking at the same text and seeing two different mechanisms. You see a shield against chaos. I see a sword hanging over the head of the citizen. The mere member is the collateral damage in your view.
Not collateral damage, participants. That is the fundamental difference. You view the unarmed person or the rank and file member as a bystander. The law views them as a participant. And as we wrap up this analysis of Articles 146 and 147, I think my position stands on the firmness of the text. These articles provide a mechanism to dismantle criminal enterprises before they act by punishing the meeting in a legal assembly and the organizing in a legal association and explicitly extending liability to persons merely present. The law disincentivizes joining dangerous groups. The structure is strict. If you are there, you are involved.
I acknowledge the mechanism exists, but the text leaves open significant questions. The specific requisites, the distinction between the one inciting and the audience, the breakdown of weapon types, and the vague definition of public morals suggest that the law is struggling to balance collective safety with individual intent. I maintain that the complexity of the text implies that mere presence should be read with extreme caution. We cannot interpret the law in a vacuum that ignores the complexity of human behavior.
That is a fair caution to have, but both of us can agree that the text establishes a clear legal reality. One does not need to pull a trigger or hold a knife to be criminally liable.
That is undeniable. Mere presence, in the wrong context, is sufficient for the law to take hold. It's a sobering reminder to know exactly who you're meeting with and why. The company you keep can determine the sentence you serve.
Indeed. We invite you to read the specific requisites in the source material and decide for yourself where the line should be drawn.
Until next time.
Thank you for joining the debate.